I don't hate hardly anybody. Hate is a very strong word. I don't hate Biden. I don't hate Obama. I don't hate Trump. I don't hate Pence. I reserve hate for just a very select few small number of people. Only two come to mind, Kamala Harris and Thomas Clair Binger. And today you're going to find out why. Thomas Binger has responded to Dominick Black's attorney on the latter's motion to dismiss 2 charges from the impending trial. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
Okay, so Anthony Cotton is Dominick Black's lawyer, and he has filed a couple of motions here. One motion concerned the hold hunting exception in the minor possession charge, the same one that Mark Richards has been hammering with Kyle Rittenhouse's case. And I've gone over that very extensively, and I'm going to go over it again today. There's another motion. It turns out that Dominick Black is being charged with 2 counts of providing a firearm to a minor. Not 1, 2. And he's doing that because Kyle turned around and shot 2 people. Well, that will settle in another video. But again, it kind of shows you Thomas Clair Binger's mindset. He wants Dominick put in jail for as long as possible. Nobody thinks that Dominick Black is a bad dude. Everybody seems to think that he's an okay guy. He was 18 at the time. He has never been in trouble with the law. He seems like an overall good kid. And yes, he probably shouldn't have allowed Kyle to take that rifle with him, but he just didn't have the courage to tell his friend no. And guess what? That's a very human trait that we all have. We all want to think that if we see somebody drunk at a party, we will grab their car keys from them and not let them drive, okay? Yeah, a lot of us would do it when we get a little bit older, but at 18 years old, nah, we're just not like that. People always don't do quite the right thing when it's going to disappoint one of their friends. And so, yeah, Dominick made a mistake, but try to put him in jail for what, 12 years for that? I mean, come on. Come on. And with Kyle, he wants Kyle back in jail because he knows that Kyle can get hurt really badly there. I'm telling you, man, Binger is an evil son of a bitch. Okay, let's go ahead and read his pretty laughable response to the motion. He might still win at the end of the day because I think that Judge Schroeder might push this off to an appeals court and may not decide to rule on this at all, but we'll see. If Judge Schroeder falls for this load of crap, wow, I'll lose all respect for him because I can see through it. All right, so he's going to discuss motion number 1. As a matter of law, the hunting exception set forth in Wisconsin Statute 948-63C does not apply to the defendant or Kyle Rittenhouse. Okay, that's the motion filed by Anthony Cotton, and that's identical to the one filed by Mark Richards, or at least one that Mark Richards is going to file for the impending July 1st hearing. Let's take a look at it. This is it here. I've talked about it a lot. And it says here that this minor possession charge only applies to a person under 18 who possesses or is armed with a rifle or a shotgun if the person is in violation of subsection 941.28, which has to do with the short barrel rifle deal, or is not in compliance with both subsections 29.304 and 29.593. Now that's the part that Kyle has to worry about. This section applies only to an adult who transfers a firearm, this is Dominick, to a person under 18 years of age if the person, again, is under 18 years of age, is not in compliance with the same whole subsections. Okay, now, this whole minor possession deal is more important to Dominick than it is to Kyle. Kyle is only facing a misdemeanor because actually receiving a rifle as a minor is only a misdemeanor in Wisconsin. Giving a rifle to a minor is a felony, and Dominick is facing 2 felony counts of that. And so he's facing 12 years. So this whole minor possession deal is really important to Dominick, not so much Kyle. Kyle, it's a serious misdemeanor. Kyle would probably get probation at most. So let's go back and let's read Binger's response. The defendant is charged with 2 counts of providing a firearm. By the way, I know this is going to be kind of blurry. You're going to have to just listen to what I say here. I don't have the original document, but this is the original document. These are photographs of it, and there's no doubt about its authenticity. This is real. The defendant is charged with 2 counts of providing a firearm to a minor in violation of Wisconsin Statute 948-62C, of course. Although simply providing a firearm to a minor is a Class 1 felony in violation of 948-62B, the fact that the minor in question has then used that same firearm to kill 2 people changes the defendant's crime to a Class H felony. Again, this is more important to Dominick than it is to Kyle. The first motion moves to dismiss the case pursuant to subsection 3C of the statute, which provides an exception to the crime if the minor is hunting. The defendant's motion incorrectly characterizes the exception as only criminalizing possession of a firearm by a 17-year-old if the minor is in violation, okay, emphasis added, so this is what Binger is emphasizing, in violation of both hunting statutes 29304 and 29593. Emphasis added. That is not what the statute actually says. Wisconsin Statute 948-63C makes it a crime for an adult to give a firearm to a minor who has not complied with the hunting statute. In my opinion, this is a mistake on Anthony Cotton, and Mark Richards made the same one. Don't change the wording of the statute. Cite it exactly as is, and then explain that not in compliance with and in violation of, for the purposes of this legal document here, this statute is for all practical purposes the same thing. And they go on to cite the actual subsection. We have already done it. There is a significant difference between not complying with a requirement and being in violation of that same requirement. Well, there can be. There's not necessarily a significant difference. Baseball Hall of Famer Robin Yount does not comply with Milwaukee Brewers team rules, but since he is retired, it would be incorrect to say that he is in violation of those rules. Rather, the rules are simply inapplicable to him because he is no longer required to comply with them. Yes, that example, it's pretty clear that there's a significant difference. But what if you're coming across let's say, a amusement ride, and you have and you're 25 years old, right? And the rule states that minors must be accompanied by an adult. Are you in compliance with that rule? I think most people would say, well, yeah, I'm in compliance with it because I'm not a minor. And so I can see it go both ways here. However, this is a point that Binger can ride, all right? The rest of his argument is just insane. There is no dispute that this exception does not apply to this case, correct? The defendant concedes that Kyle Rittenhouse was not in compliance with Wisconsin Statute 29304 and 29593. No, they didn't. They conceded no such thing. The defendant acknowledges in his brief that neither section was applicable to Rittenhouse. Then that's not the same thing as saying that the defendant conceded that he was not in compliance with. You're putting words in their mouth. If you're going to make a statement that says the defendant concedes that Kyle Rittenhouse was not in compliance, then you need to find out where they actually said that. They didn't. The defendant points out that Wisconsin Statute 29304 did not apply to Mr. Rittenhouse because he was too old, and Wisconsin Statute 29593 did not apply to him because he was not hunting. That's right. Simply put, oh man, whenever you see simply put in front of a sentence, watch out. That's called truth by blatant assertion. In other words, I'm just going to say it, and the very fact that I'm saying it makes it true. Simply put, the defendant gave a firearm to a 17-year-old in violation of Wisconsin Statute 948.60 and there was no lawful exception to that act. Okay, isn't that what you're out to prove? To say simply put and just restate it, that's not an argument. This was not a situation where an adult was supervising a minor during target practice. That's a red herring. The minor did not receive the weapon in the course of duty as part of the armed forces. That's another red herring. Neither side is making any claims about that. So why are you even bringing this thing up? And they were not going hunting. Since no exceptions apply, the defendant is in violation of the statute which prohibits him from transferring a firearm to a minor. The defendant's concession on this point, he never conceded any such point, is conclusive on this issue. Is conclusive? I have a real problem with this dude. He seems to rely on this whole truth by blatant assertion by just simply saying, simply put, this is what this law says. No, there are some exceptions that are being debated here, and they need to be addressed. And he's not addressing them. He's just saying that's what the law says, and that's the way it's going to be. And there's also this thing of putting the words in the other opponent's mouth, like saying they have conceded this point already when they have made no such concessions. But it gets better. This is where the whole train comes off the rails here. And at this point, what he's going to say next would have me livid as a judge. I would be calling him and cotton into my chambers and thrashing Binger for this. The defendant's interpretation of the exception set forth in 948.63c would swallow the entire statute, which criminalizes possession of a firearm by a minor. What? By the defendant's analysis, an adult would be free to give a firearm to a minor at any time. It could not be prosecuted? How in the hell did this guy get a law degree? The defendant misquotes the statute to require that the minor violate the hunting statutes before a crime could occur. Yeah, Binger, we've already discussed that in the previous paragraph. And the defendant argues that since Kyle Rittenhouse was not hunting, he could not have violated the hunting statutes. This logic would immunize every minor from prosecution under Wisconsin Statute 948.62a and every adult from prosecution under 948.62b or 2c. Well, I don't understand where he's getting this. It defies logic. Yeah, well, it defies logic to suggest the legislature created a crime in section 948.62a and then completely gutted it in the next subsection? Okay, let's examine this. I can't believe that he would actually even write this. All right, he is saying that the legislature created this section. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. And he is claiming that this subsection 3C completely negates it. Does it? Let's read it. This section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun. Oh, wait a minute. This is specific to rifles or shotguns if the person is in violation of section 941.28. What's 941.28? Short-barreled shotguns and rifles. So right away we see a problem with his argument. It doesn't completely gut it, because if a person is being given a short-barreled rifle, they can still be prosecuted. And if you give a minor a short-barreled rifle, you can still be prosecuted. Why? Or if a person violates this subsection, then subsection 2A still applies. Unlike what he is saying, he's saying it was completely gutted. But it gets better. Or is not in compliance with both of these sections, 29.304 and 29.593. 29.593, according to Mark Richards' argument at least, applies only to hunting. So it wouldn't gut 2A, because if you give a minor a rifle to go hunting, he's still on the hook. And 29304, let's take a look at that. 29304, restrictions on hunting and use of firearms by persons under 16. So let's take a look. Suppose you have a 14-year-old niece. Your 14-year-old niece comes over to the house and she wants to borrow one of your guns, one of your shotguns, for example. And you say, sure, take the gun down to walk around with it down to the park. Okay? Binger is claiming that I cannot be prosecuted for that because this exception that Anthony Cotton and Mark Richards outlined completely guts 2A, minor in possession, so I cannot be prosecuted. It immunizes all minors, according to him. But does it? Well, let's take a look. Persons 14 to 16 years of age. Restrictions on hunting. Well, she's not going hunting, so we'll skip that. Restrictions on possession or control of a firearm. No person 14 years of age or older but under 16 may have in his or her possession or control any firearm unless he or she, 1, is accompanied by his or her parent or guardian. No, I told her to go take the rifle or shotgun and go have fun. Is enrolled in the course of instruction under the Hunter Education Program. That's pretty damned unlikely. Is issued a certificate of accomplishment. No, she doesn't have one. Therefore, going back to 94860, 3C, even if I gave her a regular shotgun, I would not be in compliance with 29304. I would still be prosecuted. The whole Boolean thing here states that you cannot be in violation of this statute and you can't be out of compliance with both of these. It is silly, stupid to think that any minor can never be prosecuted under 94862A because of 94863C. I just gave you a very clear example of a situation where I would still be prosecuted. And so would she. So if I'm Judge Schroeder, I'm going to ask him, are you telling me that if I give my shotgun to my niece, who's 14, that she cannot be prosecuted? And what would Binger respond to? He knows he would have been caught. He would have to tell him, well, I guess technically she could. Then why are you telling me that she can't? And if you're telling me that she can't, then what are you doing as an assistant district attorney when you can't see that that would be a clear violation of the law? Okay, so on to the next paragraph. This is completely contrary to the legislature's intent to criminalize such conduct while providing reasonable exceptions for the possession of firearms by minors under proper supervision. Where's the citation for your claim? You're claiming that this was the legislature's intent. Where is your citation for that? Do you have the original Assembly bill? That would help. If you had the original Assembly bill and you could cite from that bill why they passed this law in the first place, that would make sense. But I kind of grew up in a technical writing background where if you're going to make a claim, you have to back it up. As it stands, I don't think that that was the legislature's intent at all. In my opinion, the intent of 3C was to put on extra stipulations to prevent minors from hunting unless they've had a hunter education safety course, because hunting is an inherently dangerous activity. Having a minor hunting with you is problematic, and therefore they would want young people to pass this certificate of accomplishment, which mostly centers on hunting issues. I went through that. I looked at the curriculum last time and I showed you, yes, there's some stuff in there about proper handling of a gun, but it focused mostly on hunting issues. So this whole thing about the legislature's intent is in dispute. That's why we have to justify our claims. That's why we need to cite sources, because you're going to have to persuade the judge that that was the legislature's intent, and you provide nothing here. The defendant conveniently flips the language of the exception set forth in Wisconsin Statute 94863C. Again, Cotton, Richards, you made a mistake here. You should not have done that. You left him an opening. And now he thinks that he can highlight that and somehow win the day, and he might. I'm not saying Binger is going to necessarily lose out on this. Schroeder might not even settle on this. He might just go ahead and deny the motion and then just simply let the appeals court handle it. And if the appeals court handles it, that becomes really political. And attempts to put the burden on the state to prove that the minor violated the exceptions for hunting. On the contrary, the exception is essentially an affirmative defense. Okay, I'd like to see some substantiation for that. That may be raised by a defendant, and it would normally be his burden to prove it at trial. Okay, so let me give you an example of what we're talking about. This is a motion to dismiss a charge, and you normally cannot have a charge dismissed based on an affirmative defense. With an affirmative defense, you're basically admitting to the elements of the charge, but you're saying that there are extenuating circumstances that excuse you from it. And in that case, you can't have the charge dismissed because you're basically admitting to the elements of that charge in the first place. Self-defense is a perfectly good example. Why haven't the charges of homicide been dismissed against Kyle Rittenhouse if he has such a strong self-defense argument? It's because the self-defense is an affirmative defense. You cannot use self-defense as a means to have the charges dismissed. Now, I believe I have that right. Again, it varies from state to state, keep in mind. But I think Binger is right here if subsection 3C is truly an affirmative defense. I don't see any evidence of that. Okay? Is it an affirmative defense? I would think if I'm writing this, I would substantiate that with a claim. I mean, if it's an affirmative defense, it has to be stated somewhere. In this case, however, there is no factual dispute on this point. What point? The defendant has conceded that Kyle Rittenhouse was not in compliance with the hunting exception. He hasn't conceded any such thing. Where are you getting that? Yes, I do understand that Cotton and maybe Mark Richards have changed the language of the statutes. They should not have done that. But for you to come in and claim that they conceded that they're not in compliance when they have conceded no such thing, that is absolutely absurd. As a result, the court should deny the defendant's motion to dismiss, pursuant to the hunting whatever. I don't know how Judge Schroeder is going to react to this. Oh boy, if he gets fooled by this, I don't know. I will lose all faith in the court system. Now keep in mind, they're going to have a hearing. And it could be that Binger tightens up his logic a little bit. Maybe he does provide some justification for his claims. Maybe he tries a different argument. I don't know. But right now, given what I see in front of me, I would dismiss the charge. Not necessarily because I think that Dominick Black is not in violation, but it's up to the district attorney to provide the substantiation for his charges. And if you don't, then I'm just simply going to deny them. But I'm not a lawyer. We'll see how Judge Schroeder handles it. And maybe in the hearing, Binger gathers it up and does a better job. I don't know. Like my video, subscribe to my channel.